Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from the studio on Sunday morning when we're recording this, trying to get this done before all the NFL games get rolling. Still trying to find my voice after getting wiped out with the SHOT Show crud. Hey, question. Have you guys ever tried to purchase a firearm in another state other than the one you live? Well, you know that if it's a shotgun or a non-semi-automatic rifle, no problem. But if you're trying to do that with a handgun, big problem. Big problem because of a law that was passed in 1968. Well, in the post-Bruin era, where we're beginning to kind of do a little soul searching and kind of taking a whole nother look at a lot of these laws, the good folks over at the Firearms Policy Coalition has decided, hey, this law has no historical precedent whatsoever and is candidly unconstitutional. And they have set up this argument really, really well. So today, let's spend a few minutes and let's talk about a challenge to one of this nation's most ridiculous gun laws. Okay, hey, before we get going too far down the road we're going down, proud to announce that this video is being brought to us by the Sonoran Desert Institute. That's right, get ready to launch your career in the firearm industry today through education. Get ready to start arming yourself today with education. And most importantly, get ready to start defending the inalienable rights of millions of Americans nationwide, all through education. Listen, the good folks at the Sonoran Desert Institute have a program, a degree, or a certificate for just about anything that you may desire. So for more information, check them out in the description box below, or easier yet, just visit them at sdi.edu. Okay, America, the case that we are talking about today is the newly filed case of Elite Precision Customs LLC versus the ATF. It is a case that is filed in the United States District Court for the Northern District of Texas. This is a challenge to 18 United States Code Section 922A3 and 922B3. Those laws are essentially known as the Non-Resident Handgun Purchase Ban. And so, as you know, if you've ever tried to do this, if you go to a state other than your own and you want to buy a lever action rifle, a pump action shotgun or something like that, you can go into an FFL, you will go through a background check, you clear the background check, everything is good to go. But if you try to do that with a handgun, they're not going to be able to sell to you. No, what they might be able to do is transfer the firearm to an FFL in your home state, and then you'll go through the rigmarole there. But with that comes increased delays and increased costs. Now, this suit is brought to us by our good friends over at the Firearms Policy Coalition, which means there's going to be a link down in the description box for you all to show them some love. They have set this argument up really, really well because of a previous case that actually upheld this law called Mance v. Holder. In Mance v. Holder, the same court in which this lawsuit is filed found the law to be unconstitutional. However, on appeal by the Fifth Circuit overturned that decision, finding the law to be constitutional. But, and this is important, okay, the Fifth Circuit found the law constitutional under the old two-part balancing test, okay? Not the current test, which is being used to analyze the constitutionality of gun control regulations. And more importantly, the Fifth Circuit, for whatever reason, had decided to do its own historical analysis of these statutes the first go-around. So, with a previous historical analysis already in place, FPC points out this court already conducted the type of historical analysis that Bruin requires in Mance. The court observed that the earliest known state residency restrictions on the purchase or possession of firearms occurred in 1909. They also pointed out that the appellate court had specifically stated, defendants have not presented and the court cannot find any earlier evidence of long-standing interstate, geography-based, or residency-based firearms restrictions. And the other thing that FPC very wisely points out is, we have really modernized the background check system. We are much more digitized, and therefore it is very easy for FFLs around the entire nation to be able to conduct thorough background checks on a would-be purchaser. When the federal interstate handgun transfer ban was enacted in 1968, an instant electronic background check system did not exist. But with modern technology and a much more thorough background check system, are those restrictions even necessary anymore? In short, FFLs, wherever they may be located, are required to conduct background checks under current law before they sell or deliver any firearm to a non-FFL. These checks identify both federal and state disabilities. Moreover, the defendant, Richardson, is required to annually furnish FFLs with an updated compilation of state laws and published ordinances, which is necessary for them to ensure that their firearm transactions comport with state and local law. And so this law, which may have had a purpose in 1968, has grown completely antiquated. And as FPC points out, as a result, the only function of the non-resident handgun purchase ban today is to add complexity and cost to the purchase of handguns from licensed dealers by lawful purchasers. An individual hoping to purchase a handgun from a dealer outside his or her home must arrange and pay for the out-of-state retailer to ship the handgun to a licensed in-state retailer that would then complete the sale and transfer. Not all retailers are willing to perform interstate transfer services, however, and those that typically do charge a significant fee. And individuals who desire to acquire a handgun while out of state for use out of state simply cannot do so. And then, of course, this ban also has a huge financial impact, not only on the named plaintiff in this case, but for FFLs nationwide, as FPC points out. Thus, when consumers residing outside Texas approach Elite Precision about purchasing handguns, it is company policy to decline to engage in those sales, and instead, Elite Precision offers only to ship the consumer's desired handgun to a retailer in their state for transfer there. Compliance with the non-resident handgun purchase ban thus makes Elite Precision handguns more expensive for these out-of-state consumers, and it delays such transactions. But consider some of the other impacts that this ban has on what is supposed to be an inalienable right. The ban limits their choices as consumer harms competition. The ban limits their choices as consumers, harms competition in the market, and raises prices, owing both to the fact that in-state dealers are shielded from competition by a national handgun market, and to the shipping and transfer fees that are incurred in the course of interstate handgun sales solely as a direct result of the non-resident handgun purchase ban. Now, as mentioned before, in the Mance case, when it got before the Fifth Circuit, they, for whatever reason, chose to do a historical analysis of these restrictions. And they found, well, candidly, there was no history. But again, they had that two-part balancing test where they could just put their thumb on the scale and say, it's good. So as FPC wisely points out here, defendants were tasked with trying to meet the same historical burden that Bruin expressly requires, but they could not establish an analogous tradition of firearm regulation. Defendants list the earliest known state residency restrictions on the purchase or possession of firearms, with the earliest of these restrictions occurring in 1909. Defendants have not presented, and the court cannot find any earlier evidence of long-standing interstate, geography-based, or residency-based firearm restrictions. And they also pointed out, in short, the United States could not muster any evidence of founding-era thinking that contemplated that interstate, geography-based, or residency-based firearm restrictions would be acceptable. While the test has changed, history has not. Defendants cannot meet their burden here. Accordingly, the non-resident handgun purchase ban violates the Second Amendment. And then remedies. We got to talk about remedies, right? Because if you have a lawsuit but you don't have remedies, you don't really have a lawsuit, right? The plaintiffs here are asking for declaratory judgment stating that the non-resident handgun purchase ban as set forth in 18 United States Code sections 922A3, 922A5, 922B3, and other related laws, regulations, policies, and procedures violate the right to keep and bear arms secured by the Second Amendment to the United States Constitution. And they also want to enter a permanent injunction enjoining defendants' enforcement or application of the non-resident handgun purchase ban. Listen, this is going to be a big challenge to a law that has created problems for not only millions of lawful and responsible gun owners nationwide, but also for millions of FFLs nationwide. Okay, hey, thanks for getting through this video. I am sorry that I sound so much like RFK Jr. right now. The case, once again, is Elite Precision Customs LLC v. ATF. We're going to link it up down below so that you guys can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, all you got to do is click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, America, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.